Hi everyone, welcome to the very first episode of Law Decode with M. It's a space where we break down complex legal codes into simple, relatable ideas. So today we begin with one of the most powerful economic reforms in recent Indian history. It's the Insolvency and Bankruptcy Code, or in short we call that IBC. Now don't let this title scare you because what you're about to understand affects every business, every banker, and even everyday citizens like us. So, what is IBC and why it matters? This is the enactment in 2016. It's comprehensive law that helps resolve financial distress faced by companies, partnerships, and even individuals. Earlier, we had multiple scattered laws for insolvency, and now we have one unified time-bound mechanism, which is IBC. In a growing economy where failures happen as often as successes, IBC is that law that keeps us moving. By rescuing good businesses and shutting down bad ones the right way. So, why everyone should know about IBC? That is the billion-dollar question. Let me ask you something. What happens when a company can't repay its loans? Or who gets paid first? Is it the banks or the investors or other employees? Now, should the company be shut down immediately or can be revived? So when these questions come in mind, well, IBC decides all of that quickly, transparently, and efficiently. And that's why this code isn't just for lawyers. It's for anyone who wants to understand the power play behind corporate debt. Now, to understand how IBC had replaced the old laws, we need to understand what was the enactment before IBC. So we had the Companies Act for some provisions. We had something called SURFACE for security enforcement, and even SICA for sick companies. Each law had loopholes, each process dragged for years, but in 2016, they were all brought together under the single code, giving birth to the modern-day insolvency law of India. And this has become the comprehensive code. Let's dive into the top 3 sections of IBC. If you're a law student or an aspirant, you absolutely need to remember these 3 key sections. One would be section 7 of IBC, which talks about a financial creditor, like banks or any financial institution who has lent money to the company. And these are the people who can initiate insolvency if a company defaults. Now, section 9 deals with operational creditors like vendors or the ones who supplied goods and services. They can also initiate insolvency if a company defaults. Section 12 is another important section of IBC, which talks about the entire resolution process timeline, which must be completed within 180 to 330 days. And remember, these appear again and again in future episodes, and this is just an overview for no more endless litigation. Now, let's quickly go over the process of CIRP, which is the Corporate Insolvency Resolution Process. At first, a creditor or a debtor files a case before the NCLT in the form of an application to the National Company Law Tribunal. Once this application gets admitted, a moratorium period kicks in. That means there is no new lawsuits or no recovery actions can start. It's a legal pause on all legal proceedings against the corporate debtor. Later, an interim resolution professional gets appointed and a committee of creditors is formed. Then the bidders are allowed to submit revival plans for the corporate debtor. And if all of this happens within the timeline, and if approved, the company gets revived. If it is not approved by the NCLT, then the company goes into liquidation. So as simple as that, at least on paper. We'll decode each of these in detail in the upcoming videos. Now let's understand why IBC changed the game. So what makes IBC a game changer? This has basically improved India's ease of doing business score globally, and it stopped promoters from using loopholes to stay in control. It has helped recover lakhs of crores in bad debts, and for the first time in Indian law, it gave the creditors the real control over the future of a failing company. Now, let's understand who decides all of this and what is the role of NCLT in IBC and where does all of this happen. So, the National Company Law Tribunal, or the NCLT, is the adjudicating authority for corporate insolvency under IBC. India has several NCLT benches across major cities. All CIRP cases, whether initiated by a financial creditor, operational creditor, or the corporate debtor, goes here first. Now, if the parties are unhappy with the order passed by the NCLT, they have the opportunity to appeal to the NCLT, which is the National Company Law Appellate Tribunal. And if there's still a question of law, they can finally approach the Supreme Court of India. So here's the hierarchy: NCLT, where the CIRP begins, NCLAT for appeals from NCLT, and Supreme Court has the final say on legal issues. This structure basically ensures faster justice and minimum interference. Now, what's coming next? This is the sneak peek, and this is just the beginning. In upcoming episodes, we'll explore real case studies under IBC, like the Go First case, Jet Airways, DHFL. We'll break down all of these advanced topics, especially legal provisions of IBC, which deals with Section 29A, liquidation, fast-track insolvency, PPIRP, and even cross-border insolvency, all in a way that makes sense. So if you've ever felt that corporate law is too dense or dull or complex, it's not anymore. If you found even one thing that clarified your understanding today, this channel is for you. Feel free to drop your questions or suggestions for the topics in the comments. Let's build this legal knowledge space together, one concept at a time. So if you want to keep learning law that actually makes sense, well, you know what to do next.